Last month, we discussed a growing trend in state legislation attempting to put control of personal information back into the hands of consumers. As we wait to see how Texas and eventually the federal government will act, we can perhaps gain foresight by looking at common provisions appearing in privacy legislation both in Europe and in the States. Right now, we can identify 16 of these provisions. They can be divided into two categories: consumer rights and business obligations. There are 9 consumer rights provisions. First is the right to access collected. This refers to the right of individuals to access from a business the information or categories of information the business has collected on that individual. In some cases, the right may only exist if information is sold to a third party. Second is the right to access shared. This allows consumers access to any personal information shared by a business with a third party. Third is the right to rectification. This means a consumer can request that incorrect or outdated personal information be corrected. Fourth is the right to deletion. Under certain conditions, a consumer can request their personal information be completely deleted by a business. Fifth is the right to restriction. This would allow a consumer to limit a business's ability to process their personal information. Sixth is the right to portability. This is the right of consumers to request that their personal information be disclosed in a common file format. For instance, if a consumer wants to transfer their account to another business, they could transfer all of their information as well. Seventh is the right to opt out. With this, consumers could opt out of the sale of their personal information to third parties. Eighth is the right against solely automated decision-making. This prohibits businesses from making decisions about a consumer without any human input. Ninth, and finally, is the private right of action. This allows consumers to seek civil damages for violations of a statute. Now let's take a look at the 7 provisions related to business obligations. The first is age-based opt-in. This obligates businesses to treat consumers under a certain age with an opt-in default to sell their personal information. The second is transparency requirements. These mandate businesses provide notice to consumers about certain data practices, privacy processes, or privacy programs. The third is data breach notifications. This obligates businesses to notify consumers and authorities about privacy and security breaches. The fourth is risk assessment, which requires businesses conduct formal assessments of privacy and security projects and processes. The fifth is a prohibition on discrimination. This prevents a business from discriminating against a consumer for exercising a right. The sixth is purpose limitation. This restricts a business in collecting personal information to a specific purpose. The seventh and last is processing limitation. This is similar to the previous one, except that it restricts a business from processing personal information except for a specific purpose. Not every proposed privacy bill contains all 16 of these provisions, but these have all popped up frequently. Here in Texas, 2 bills have been proposed. Both have yet to make their way through committee, but we can take a look at how they currently stand to get an idea of the provisions we are likely to see in their final form. House Bill 4518, known as the Texas Consumer Privacy Act, carries 8 of these common provisions in its current form, and House Bill 4390, known as the Texas Privacy Protection Act, contains an additional 3 provisions. Whether these 2 bills pass in Texas or not, at some point we will have a comprehensive privacy policy on the state and federal level, and this has implications for both consumers and businesses. As consumers, this means legislators will and are deciding what rights you have when it comes to accessing, sharing, protecting, and controlling your personal information. We need to stay informed and let our representatives know what we want. For businesses, comprehensive privacy reform could very well change standard operating procedures, as we must create and implement new processes to fulfill new legal obligations. We should be discussing solutions now in order to stay ahead of the trend and maintain consumer confidence. If you need help securely storing or destroying your files, call DSS toll-free or visit our website at docshredders.com.